We appreciate you guys. You guys are good.
Doesn't matter if Jesse gets in trouble. Amila said, where is he?
Members, I'm told we're back up and running. And the floor remains at this time with Councilor Davila. We are on the motion to refer this item to committee. The motion was made by Councilor Kern. Councilor Davila on the motion.
Thank you, Mr. President. Did Director Mahoney leave, or? Oh, he's still there. Okay.
So move the vote.
Director, before I say anything else, I thank you. And I will admit to you, if anybody knows me, they know that if I don't understand something, I'm going to ask questions. And honestly, sir, I am more confused now than 10 minutes ago. I do not understand your answers. If I'm a supervisor, I will feel that I'm standing in front of a firing squad constantly. I will feel that a noose is around my neck all the time. Now, a comment was made a little while ago about livelihoods. It is true. But this is also their livelihood. Now, again, I'm the first one that want the cops to be oversight. I'm the first one who say we need to have a strong oversight, including supervisors. But I am uncomfortable mainly because I don't understand what it is, the 90 and 120 days, because at some point, there's got to be a resolution. Cops deal with so many people a day that it will be a constant threat to them. I want to ensure, and the cops to know, that if you're a good cop in the city, we got your back. If you wear that badge with honor and you do your job honorably, I got your back. If you are not doing the right thing, if you like to violate people's civil rights, then we will prosecute you accordingly. We will go after you. And so, some people might say, well, here we go again. I understand that you should understand it. Well, no, it doesn't work that way. Maybe you understand it. Maybe some councilors here, I can see some of them do understand. I don't. And at the end of the day, we're talking about people's livelihood as well. Because those guys in the police department, the supervisors, have put in the sweat, the time and effort and the sweat for this city. So, I'm going to ask you one more time to see if you could please explain to me, if something happens to me today and I don't say anything until February 14th, which is 90 days, when does my ability to bring a charge against that supervisor expires? Assuming that it's not a felony. I know a felony is a whole different thing.
There is no expiration date after the 90 days. But if we are not aware of it, if the Springfield Police Department is not aware of it, it can be brought at any time. However, it may not be upheld by an arbitrator if discipline were imposed. So if it's very stale, if it's very old, they may investigate it still, but there may not be any charges that could stick to the officer. But there's no additional timeline in any of the contracts beyond the ones that we've already discussed tonight, the 90 for the supervisors and the 120 for the patrol officers.
So you're saying that it's 90 for the supervisors and 120?
That's the current, right now, that is currently what we have, 90 for supervisors, 120 for patrol.
So why the difference between the two?
Well, it was 90 for both, and the police patrolman had a very narrow 60-day window to actually have the charges brought forward. That language was changed to the language that we currently have in the contract, which says if we weren't aware of it, we can bring it later. It's the burden's on us to show why we went beyond either the 90 or the 120. That burden is on us, and an arbitrator could say, it's not good enough, you can't bring it forward.
Right. I understand that our only role here is to accept it or reject it. I understand that. I understand that this was done between the city and the police union, excuse me, the supervisors union. I get that. But I don't feel comfortable with this particular thing. And so, at least on this particular item, Mr. President, I will be voting in favor of the motion to send to committee. Thank you, Director Mahoney, thank you.
Sure.
Thank you, Councilor Davila. We're going to go to Councilor Curran at this time.
Thank you, Mr. President. To Councilor Davila, I don't blame you because I was confused as well, along with you, with the explanation. If you, on day 91, the offense is discovered, I think under the language as before the council, they would have a pretty good defense. And I guess again, the point of the discussion is why not agree with the DOJ recommendation of the 120 days? If I can remind my colleagues, this contract, as it comes due in January, I mean, we may not have a resolution to this for another 3 years because there's no telling that the next contract will be agreed to. So we might be stuck with this 90-day language for the next 3 or 4 years coming. I guess my question to Attorney Mahoney is, if we do put this into committee and the union, the supervisors union, were to agree with it, could the city come to an agreement of increasing this language to 120 days in the interest of transparency? You stated that this was the DOJ, one of the most important points that the DOJ is looking for. You stated that you're looking for it. If we put this to committee and there was an agreement before we sign off on this, could we increase this 90-day period to 120?
Well, I didn't say this was the most important, or one of the most important points for the DOJ. The DOJ's settlement agreement with the city is 69 pages long. So this is a point, and when we looked at it, we had what we identified for labor relations were 9 points that we needed to negotiate with our two units. And when we looked at the 9 points, knowing we can only bring 5 forward, this did not make our top 5. With that being said, this piece is not even in play right now, but it will be in play the next time we go to the table for negotiations with the police supervisors. And the DOJ's language was not 120 days. I believe it was an unlimited number of days, and we came down with a compromise with the IBPO at the 120. I think that's how we agreed, because we knew we weren't going to get the full unlimited time period to bring charges against someone. So we expanded the period a little bit. I'm hoping that's satisfactory to the compliance evaluator. And if it's not, we're going to have to come back to the table again on it. But
my question is, if this is sent to committee, could we change it to 120 days?
you can't change the award at all. You could negotiate something other than the award and then pull this from the council, but you can't change the award itself.
This particular provision, though, if there was an agreement.
This is not a provision in the award. This does not, whatever we've been talking about on the 90 and 120, that is not part of this award, and that is nothing that is in front of this council. That's a separate issue that can come up down the road, and you could negotiate something completely different from this award and say, we're going to pull this award from the council and we're just going to make a settlement agreement on other terms, but you can't change this because it's not in the award.
Could you provide this clarification? Would you be able to do a side letter on this award with this language, increasing this language at this point?
Sure. If the union wanted to do a side letter to increase, to make this concession to the city, we can do that.
So if we send it to committee, we could do a side letter if the union were in agreement.
Yep, I would just express to the council.
Is that yes or no? I mean, is that possible?
Well, anything is possible in labor relations, but I would point
No,
out,
is it yes
I
or
would
no?
point out,
If
I would
there was a
point
side
out to the
letter and the
council,
union were in agreement,
I would
we
point
could
out
do
to the
it.
council that since this award has been issued, there's not been any, overtures as far as let's make a different deal. That has not
But that's
occurred.
not my question. I can see why your negotiations take 3 years.
Thank you.
I mean, the question is, if there's a side letter and this goes to committee and the union is in agreement, could we increase the 90 days to 120? And we have the committee meeting within 2 weeks. Could we do that?
The union can sign a side letter tomorrow about that, yes.
I don't know, Mr. President, is it possible? Well, that's the reason I would suggest to my colleagues why we would send it to committee. We have the opportunity now to move this from 90 to 120 days. If we simply allow it to take the course of negotiations, it could be like 4 years before this comes back. And the name of the game, the reason why we want it to 120 days is in the interest of transparency. So I really do think that moving this to committee is simply adding 2 weeks to this negotiation. I actually think it's really integral and at the heart of the negotiation, because we really do have an opportunity to move the 90-day window if the union is in agreement with a side letter to 120 days. And I think that makes a lot of sense. They'll be in alignment with the patrolmen. The patrolmen's union.
They could also.
So again, I would support the motion, move it to committee, because my idea is once we get into committee, we can ask the union to agree to up the 90-day statute of limitations to 120 days. And I think that's a lot more equitable. It's a lot more transparent. And I think it's really in line with the Department of Justice wants. And I think it's in line with the residents of Springfield want.
You could also have that done without going to committee by just having conversations with the union, between the administration and the union after this, if they want to talk about a side letter. But I wouldn't delay.
Yeah, but you haven't been able to do that for
I
years.
would not delay this any longer than it is.
I don't think a 2-week delay is unreasonable. You haven't been able to get a contract signed in 2 years, and I can see by your somewhat combative tone and confusing tone why. I mean, I would suggest again, there's a motion on the floor to put it to committee. Before we proceed with the motion, Mr. President, I would like to hear from the union president there in the chamber and ask, would the union president object to considering increasing the 90-day statute of limitations to 120 days?
Captain Keenan, if you wish to be heard, you have the floor at this time.
Thank you, Counselor. The union is always ready and willing to do business with the city in issues of transparency. So if that's what the council needs, we're certainly willing to sit down and do that.
Councilor Kern?
Thank you, sir.
Thank you, Councilor Kern. Thank you, Captain Keenan. There are many hands up, and I am going to recognize all of you. Councilor Allen has not spoken yet, and so on the motion, Councilor Allen will be recognized. Councilor Edwards has also not spoken yet. So we're going to go on the motion to Councilor Allen, followed by Councilor Edwards.
Thanks, Mr. President. I really want to call the question. I think we've been talking about this long enough. Let's call the question, vote on the committee thing. It's 9:30. We've been talking about it for an hour. We aren't any farther along than we were an hour ago. So I'd like to call the question, please.
Councilor Allen has made a motion to call the question. That motion was seconded by Councilor Whitfield. We'll now vote on the motion to call the question. This is a motion to call the question on the motion to committee. It requires 9 votes to pass. If it passes, debate will be ended, and we will proceed immediately to the vote on the motion to committee. So at this time, on calling the question, Madam Clerk, please call the roll.
On calling the question, Councillor Walsh.
Councilor Brown has a
Yes.
question. Councilor Brown?
No, this is not on the actual sending the
Correct.
committee.
This is on calling the question. If you vote yes, you are voting to end debate. If you vote no, you are voting to continue debate on the motion. On the question, please call the roll.
On calling the question, Councillor Walsh.
Yes.
Yes, Councillor Fenton.
Yes.
Yes, Councillor Perez absent. Councillor Whitfield.
Yes.
Yes, Councillor Govan.
Yes.
Yes, Councillor Allen.
Yes.
Yes, Councillor Brown.
Yes.
Yes, Councillor Hurst.
Yes.
Yes, Councillor Click Bruce.
Yes.
Yes, Councillor Edwards.
Yes.
Yes, Councillor Curran.
Yes.
Yes, Councillor Davila.
Yes.
Yes, Councillor Letterman.
Yes, the votes are sufficient. The question is called. Madam Clerk, please call the roll on the motion to refer this order to committee. A yes vote will refer the matter to committee. A no vote will return us to debate on the petition. Madam Clerk, please call the roll on the referral to committee.
On the motion to move to committee, Councillor Walsh.
Yes.
Yes, Councillor Fenton.
No.
No, Councillor Perez absent. Councillor Whitfield.
No.
No, Councillor Govan.
No.
No, Councillor Allen.
No. Excuse me, no.
No, Counselor Brown.
No.
No, Counselor Hurst.
Yes.
Yes, Counselor Click Bruce.
No.
No, Counselor Edwards.
Yes.
Yes, Counselor Curran.
Yes.
Yes, Counselor Davila.
Yes.
Yes, Counselor Letterman.
Yes. The vote is tied. And council, I've never had to do this before because this has never happened to me. But I have to refer to the rules relative to the tie unless former Council President Fenton knows off the top of his head, or Councilor Hurst, in the event of a tie.
Majority of the council, not those present.
It's a dead tie.
It's a majority of the council, not those present.
So there's 12 of us
It
present.
loses.
Oh,
No.
no.
6 of us have voted to refer to committee, and 6 of us have voted to not refer to committee.
Right, but it's a majority of those counselors, not those present. So there's 13 counselors, a majority is 7.
So the motion fails.
The motion fails.
The motion fails.
Yeah,
It's getting late, folks. The motion has failed. At this time, we will return to debate on the order. And the order is to approve the arbitration agreement. On approving the arbitration agreement, Councilor Brown.
Thank you, Mr. President. Having a lot of knowledge on internal affairs and how the police actually go through the process, what individuals have to understand, and if I may, I want to, if you can, sorry. Just so, you know, some of my colleagues would understand. So basically, if 8 months from now, a year from now, I did something that warranted an investigation that still went beyond that 90 days, it would go into a certain area where they would investigate to see if they had enough information to prosecute. So say there was a rogue cop who was robbing people at gunpoint and they have him on camera. And then a year later, if they have enough evidence to actually persecute it and it's egregious enough, they will do so. A lot of times, if an individual comes across a situation with a police officer, they're usually going to notify the necessary people within that amount of time. So that 90 days, that 120 days, it means absolutely, it means a little bit if they did something a year from now and it warranted an investigation from IAU, would they or would they not investigate it?
They're going to investigate it.
And the individual could get in trouble. Could they or could they not?
They could. Yes.
So what we have to understand is we're talking about, if I want to introduce, see what we're doing now is there are people who, I don't know, might want to work on not getting hit by horses. That might have been one of the 1,000 things in there. They only picked a few. They could have got to, there's a lot of good issues. So this wasn't even brought up. This isn't on this thing today. We're not talking about, I don't know, cops at the basketball, when we might need cops there to do better. We're not talking about that. We're not talking about 90 days. We're not talking about that. We're only talking about today, the 5 things out of a trillion that these individuals negotiated. And once again, the 90 days, the 120 days, that isn't even on the table. There's other issues that they brought up at this particular point. Okay, and like I said, they can always bring up prosecution if there is enough evidence to do so. And usually majority of the time, if it's that atrocious and they find out, they still will prosecute, correct?
They can still bring charges and, yeah.
Thank you.
Thank you, Councilor Brown. On the approval, Councilor Whitfield.
So Councilor Curran brought up some information that I wasn't quite aware of. I did not realize that if we did go to committee that we would be able to renegotiate the terms. I thought based on what we were told that when it went to mediation arbitration, that it was 100% final and nothing could be done to change the contract. So I think we kind of like missed our window of opportunity to discuss. I went to the bathroom and thought about it. Some of the changes that we could actually really still make in the contract. I didn't realize that that could still happen. I thought once they went to arbitration and it was decided on the 5 issues that it was done. So can you repeat to me how you can still negotiate changes in the contract, or is based on arbitration everything final?
So this is an arbitration award and decision. This is final, subject to your funding it. If you fund this, this is the contract for the next 4 years. If it's not funded, we would go back to negotiate, and we would try to come up with something else, or we may end up in a different procedure in front of DLR, Department of Labor Relations. But this is the process. This is the closure mechanism, is what we call it in our field. This is the closure mechanism for police and fire cases. So you go through negotiation, mediation, interest arbitration, and you get a decision. And then it's binding on us, it's binding on the union, subject to funding by the council. And if you vote it up, that's the deal for 4 years. You get those police reform issues that we've talked about, they're done. But we're going to go back to the table anyways in January and start a whole second round or another round for FY 25, 26, et cetera.
Because it goes from 2020 to 24.
This would cover your FY 21 to 24. Those years will be done and wrapped up, and then we move on to the next round.
Now, if we had put this in committee and we had a discussion, and you had a discussion with the officers, we could still change the 2020 to 24 contract to 120 days.
So with all due respect, the committee doesn't get to negotiate anything.
I'm saying you and the union.
And we have been at that since 2020. I don't think that's going to change what we're doing today. Just being honest
But
about
just
it.
to answer the question, it could.
Anything can happen, yes, anything can happen.
But when do you start your next negotiations? Like, is it January?
We
Is
could
it
start,
March?
the next cycle could be started in January, and those issues that we didn't resolve here, the city will be bringing them back. And the issues that the union didn't resolve, they're going to want to bring those back too. So things that both sides didn't get in this thing, I'm sure they're going to come back and we're going to talk more about it.
I think we had an opportunity to do something when we were sending it to committee, but right now, I think that they need to get paid. I'm sorry, I just can't go no other way. And I'm going to move the question.
Mr. President.
A motion has been made to move the question. Motion was made by Councilor Whitfield. It was seconded by Councilor Govan. We are proceeding to a vote to move the question, subject first to the point of order called by Councilor Davila. But if it's not a point of order, I'm going to call it out of order. Councilor Davila?
Yes, I could be mistaken, Mr. President, but I do believe this is a very important subject. My understanding of the rules is that if you speak on the issue, that person cannot call the question.
That is not, I think that me and Councilor Davila have actually had this debate before, and I think that we checked on it, and I do think that you can call the question.
You are the parliamentarian, sir, but I do stick by the belief that if you speak on the question, on the issue, sir, you cannot call the question, but you are the parliamentarian, not me, sir.
The motion was made to call the question. Councilor Whitfield made the motion. Councilor Curran, do you have a point of information, Councilor Curran?
Just I would oppose the motion to move the question. I would actually ask Councilor Whitfield to consider withdrawing that so I could put a motion to revisit the committee. Because to answer her question, yes, at committee, we can
Councilor
change it from
Curran,
90 to
Councilor Curran.
120 days.
Councilor Kern, I apologize, but you're out of order. The motion was made to call the question. I understand Councilor Davila's point, and, you know, for that reason, I'm going to call a 2-minute recess. I'm going to consult the rules, and we're going to determine whether Councilor Whitfield's motion to call the question was in order. She did speak on it. I understand Councilor Davila's point of order. Because there are multiple other councilors that do want to be heard, for that reason, I'm going to call a recess, and me and the clerk are going to consult the rules, and then we will return with a ruling. I am sorry, Councilor Edwards, but we cannot hear any further debate because of the order.
Can a question regarding the need for you to take more, a request for more clarity when you do meet with the clerk?
Councilor
that
Edwards, on a
appropriate?
point of information, Councilor Edwards.
Okay, a point of information, when you meet with the clerk, can you come back and be prepared to answer the question of whether or not we can revisit the motion to send back to committee? Is
Yes.
that an appropriate request?
It is
Of
not.
you as the parliamentarian?
It is not, and again, I'm doing this because of the order of what happened. So just to be clear, Councilor Whitfield spoke on the motion. She then, or spoke on the order. She then made a request to call the question. Normally, we would proceed to a vote. I understand Councilor Davila's point of information. Because there are councilors that want to be heard, out of respect for all of you, and I'd do it for any one of you, we're going to call a recess, we're going to consult the rules, we're going to go from there. Council stands in recess. Council will be in session. Councilor Davila. Rule 31 of the City Council rules state that the previous question shall be in the form of the motion to move the question. It shall be admitted when demanded by 2/3 of the majority members in quorum are present, and until decided shall preclude all amendments and debate of the main question. And after the adoption of the previous question, the sense of the council shall forthwith be taken upon amendment, report by committee upon all pending amendments in their order, and then upon the main question. Our rules do not mention anything relative to the request that you made. However, when our rules are silent, they defer to Robert's rules. The clerk and I looked at Robert's rules. We did not find anything pertaining to the statement that you made relative to individuals not being able to speak. However, regardless of that, our rules explicitly speak to moving the question and do not say that you cannot move the question after you have spoken. And so with that, I rule that Councilor Whitfield may move the question. And I do apologize to the audience for the delay. However, given that this was a point of great debate and contention, I felt that it was important to ensure that we proceed with as much accuracy as possible. With that, we will now return to debate on the order on passage.
I would like to withdraw the motion to move the question.
Councilor Whitfield has withdrawn the motion to move the question.
Sorry. Can
Mr.
I make
Mr. President?
Can I make a different motion?
With the motion withdrawn, we are now returning to debate on the order. If you are an individual who would like to speak, Councilor Curran, I hear you. If you are an individual who would like to speak, I would ask that you raise your hand at this time if you would like to speak on the order.
Is it still my turn?
The floor is clear. You withdrew your motion. I am now going to recognize councilors who wish to be heard, starting with you.
Okay.
But then we are going to go to Councilor Brown. Councilor Whitfield.
Thank you, Mr. President. Sorry for the confusion, guys, but I want to send this to committee. Make a motion to send it to committee.
Councilor Whitfield has made a motion to refer this item to committee, was seconded by Councilor Davila. Is there any further discussion on the motion to committee?
Call the question.
Seeing no further, is there any further discussion on the motion to committee? Seeing no further discussion on the motion to committee at this time, without objection, Madam Clerk, please call the roll on the motion to committee. A yes vote will refer the item to committee.
On the motion to committee, Councilor Walsh.
Yes.
Yes, Councilor Fenton.
Yes.
Yes, Councilor Perez, absent. Councilor Whitfield.
Yes.
Yes, Councilor Govan.
Yes.
Yes, Councilor Allen.
No.
No, Councilor Brown.
No.
No, Councilor Hurst.
Yes.
Yes, Councilor Click Bruce.
Yes.
Yes, Councilor Edwards.
Yes.
Yes, Councilor Curran.
Yes.
Yes, Councilor Davila.
Yes.
Yes, Councilor Letterman.
Yes, the votes are sufficient. The matter will be referred to the General Government Committee. Madam Clerk, is there any further business properly brought before this body?
There is not.
Seeing none, we will stand adjourned.